So my name's Penny Lewis. I'm a lecturer in architecture at the University of Dundee. I'm on the advisory board for the Scottish Free Speech Union, and I'm a board member of the Scottish Union for Education. So I've got lots of fingers in the pie here. I'm here to welcome you to the University of Dundee. I'm really happy to see you all here. About 3 weeks ago, there was a moment when we thought this event wasn't going to be able to take place. And you may not be surprised to hear that it was members of the student union and members of my former union, the UCU, that actually protested to a safeguarding committee, suggesting that this was going to be an event that shouldn't be supported by the university. Anyway, happily, the university stood by its commitment, at least on paper, to freedom of speech, and they told the complainers that this is exactly the sort of debate that we need to be having in universities. So this is the first time that the Free Speech Union, at least in Scotland, has held a meeting at a university, and I think it's a great step forward that we can actually occupy public space like this in a way that we haven't been able to, perhaps sometimes in the past. Thank you very much.
Thank you. Thank you, Penny. I hope you can all hear me. A big thanks to Penny for making this happen and for facing down the would-be councillors. We really thought there might be a horde of protesters outside the... Slightly disappointed, actually. There are none at all. More police officers than there are protesters, because there was a single protester, but nevertheless, great that we're able to do it, and a big thank you to the staff and to Dundee University for letting us this outrageously far-right panel assemble on their premises. Anyway, and thanks to all of you for coming. I'll quickly introduce the panel and then we'll get stuck in. And we're going to speak for about 45 minutes, and then it'll be up to you to ask us questions for the next 45 minutes. And then we'll reconvene at the Contemporary Arts Centre for drinks. Okay, so on my right, we have Dr Claire Methven O'Brien, who's a lifelong human rights advocate, researcher and practitioner, and she's a reader in law at the University of Dundee School of Law and a member of the Scottish Human Rights Commission. To my far left, quite literally, is Joanna Cherry KC, who was the MP for Edinburgh South West from 2015 to 2024, and latterly she's chaired the Parliament's Joint Committee on Human Rights, and she's now returned to her practice at the Scottish Bar and is a trustee of the LGB Alliance and a member of the advisory panel of the Free Speech Union of Scotland. To my immediate left is Dr David McGrogan, who is, or is it McGrogan? It's McGrogan. Dr David McGrogan, who's an associate professor of law at Northumbria Law School, and his research looks critically at international human rights law, with particular reference to how it serves to buttress the power of the state. And finally, on my far right is, and I think that's pure coincidence, is James Allan, who is the Garrick Professor of Law at the University of Queensland, with a special interest in legal and moral philosophy, constitutional law, and bills of rights. And in case any of you don't know me, I'm Toby Young. I'm the founder and general secretary of the Free Speech Union. So Claire has very kindly agreed to lead us gently into this discussion by setting out some definitions, laying the groundwork, giving us some guide ropes before we start going for each other's throats.
There's, of course, a great deal of speech about human rights, and human rights are a source of contestation, both things I think, the FSU should be pleased about. But, in the context of a panel debate about human rights, it's just useful, I think, to take it before we get, right into sort of mortal combat about whether we should depart the European Convention and other more sort of local issues. Just useful to take a step back and think about what are human rights, what do we mean about when we talk about human rights. We can distinguish, of course, the idea of human rights as natural rights. For some people, when they talk about human rights, make claims about human rights, they're talking about rights separate from any legal rules which provide for human rights. They think that human rights are things which are just kind of intrinsic to the fabric of society or universe. We have then the idea of legal human rights, and for lawyers, when they talk about human rights, really that's what they mean. They mean specific norms that have got a content that derives from a treaty or a statute. Other people, campaigners, when they talk about human rights, may be talking about political claims that relate to justice and equality, which are again quite separate from the specific legal meaning in a specific jurisdiction of human rights. And then, in society at large, we can also sort of detect a discourse, a broader discourse of meaning around human rights. So, when we engage and politicians engage and, people on TikTok engage in discussion about human rights, we'll often find these at least four different meanings of human rights cutting across each other. And people may be having discussions about human rights, not even appreciating that there is this room for distinguishing different senses of human rights, which can generate a great amount of heat and confusion and difficulty when, as specific democracies, we try to navigate the issues that are presented by given human rights regimes, be that the European Convention, United Nations human rights institutions and norms, or things that happen more locally. Again, if we think about Scotland in terms of the recent debates about incorporating human rights treaties from the United Nations system into the domestic legal system. So I just thought it would be, it's useful for us to ventilate, those issues, so that as a bit of, housekeeping, sort of conceptual housekeeping at the beginning of this kind of discussion, at least so that we can all, know what we're talking about.
And do you want to make a defense of one of those conceptions of human rights, the legal conception? How do you think they've been helpful when it comes to regulating our politics? Have they been helpful as a bulwark against the resurgence of tyranny in Western Europe, for instance, since the Second World War? Are they meaningful and worth fighting for, worth preserving?
Yeah, I came to human rights in the 1990s, as some of the people in this room will have done. The context in Britain at that time was one where human rights were not given domestic legal protection. All we had was civil liberties, which were divined, from the dusty entrails of ancient case law by the judiciary. And, they might or they might not be protected according to, specific judicial decisions. And for me, the attraction of human rights is that they are anchored in the idea of entitlement to equal consideration and freedoms as a result of being a human being. We are human beings made out of the same stuff. We come from the same places. They connect, therefore, to our material reality, the material realities of human existence. They disconnect legal protection and rights from purely metaphysical or divine or a socially contrived basis that allows states to erect differences or special claims in law that prioritize one group over another. And that, ideal remains a really important benchmark, I think, against which we can constantly check and evaluate government performance, market and social arrangements. And I think that has got real value in terms of a basis on which to generate data and empower people, us, rights holders, and to enrich and structure the democratic process. And that was really attractive to me in the 1990s in the UK as it was then. And I think we do still need explicit, positive, and democratically mandated rights. Yes, I'm a Republican to that extent. We don't have a written constitution in the United Kingdom. We don't have constitutional rights, and that entails a risk of political disenfranchisement and disempowerment. And let us not, forget how long, in the absence of a constitutional Bill of Rights, the judiciary and other organs of government were able to maintain socially regressive and unequal relations. So, Yeah, so I think that's the intrinsic value. You can argue, of course, about the specific instantiation of human rights in the Human Rights Act, in the European Convention, in United Nations instruments. And I think, yes, we need to have discussions about the areas in which we've gone too far. We can have a debate about, the specific conjunction of the European Convention and the Refugee Convention and the directions that's taken us into and the limits that entails in relation to border control and the deportation of foreign criminals, which is has been a key initiative taken by Denmark and Italy, 9 other Council of Europe states in the last few weeks. They've pressed all the Council of Europe member states to have a discussion. Has the European Court of Human Rights gone too far in those areas? Has it taken the interpretation of the European Convention beyond what was originally intended and resulting in the frustration of the democratic impulse in across the European continent? Let's have that discussion. I don't think in the case of the United Kingdom that means that we necessarily have to withdraw from the European Convention. Take Brexit, Norway, Switzerland, other countries are not part of the EU. Leave the European Convention, whose company are you in? And I think, there are important insights there. Many countries that have very robust internal discussion that are, in some respects to the right, also to the left of the United Kingdom, still manage to retain their membership of the European Convention on Human Rights without that curtailing or restricting necessarily the spectrum of political possibility. So I think it's a mistake to think that departure from the European Convention is necessary in order to achieve political transformation or a different package politically than that which we have now.
Okay. All right. Thank you, Claire.
Do we get to respond?
You
She's wrong on every single thing she said.
Okay, you come straight in, Jim. Come straight in.
Okay. No offense to Claire. So this is a Canadian accent. You can add 5 points to my IQ because you said Canadian accent. So look, here's a better way to think of it, I think. A right is another's must claim. If you claim to have the right to free speech, other people must let you speak. It goes back to Bentham. It's basic. And so the real question, and you can take any right and translate it into the language of rules. There's not a single right that I can't translate into the language of rules. Rules are desiccated. People don't want to hear rules. Rights give you this tingle down your spine, and you think, oh my God, entitlements. The problem fundamentally with rights is they're pitched up in the Olympian heights of abstractions. I have done millions of sort of debates with people, and you go, who's in favor of the right to free speech? The guy with the brown shirt and the little mustache puts his hand up. Everyone's in favor of the right to free speech. But when you start saying, can you advertise tobacco outside of schools? Canadian Supreme Court said you could. What about campaign finance? The problem with rights is when you descend down into the quagmire of day-to-day decision-making, nice, reasonable people you'd have a beer with disagree. So the real question is, who gets to make these calls? And Claire pretends that when she says we, it's not we, it's a bunch of unelected judges who are making these calls. That is the problem. It is fundamentally undemocratic. And you can disguise that all you want. But, I've made a career out of this. The real problem is, if you go back, look, Australia, where I live, does not have a Bill of Rights. There's more scope to speak your mind today as we speak in Australia than there is in Britain. And in Canada. And that is just fundamentally true. We don't have police going around giving us sort of non-crime hate speech things. And here's another thing about rights.
You have conversion therapy legislation.
I didn't interrupt Claire.
But you have
is that what we're doing?
I have to take charge. You can come back.
Yeah. Thank you.
Crazy.
The biggest inroads on our civil liberties for 300 years were the 2.5 years of COVID restrictions. There isn't a single jurisdiction in the democratic world where anyone went to court and successfully had a judge say, we're going to strike that down. There was a case in Scotland about, big box stores and churches and 1 or 2 in the States. Basically, nothing. The grooming gangs, what have bills of rights done? Nothing. So the real problem is, when you buy a Bill of Rights, you buy the outlook and views of the lawyerly cast. And by the way, I have to just have a diversion because I met Toby during lockdown. He and I were 2 of the early people who were against the lockdowns from about March of 2020. And I've been promising to bring him this shirt. you can see it's the ascent of man and then down to sheep. So I hereby pass, I don't want, I have passed.
I won't put it on just yet, but yeah. All right, thank you, Jim. So you disagree with some of the things Jim
I disagree
said,
with everything
Joanna.
Jim said.
Okay, we have a debate on our hands. That's
First
good.
of all, he started out with a fundamental mistake. The right to free speech is not a must, it's a qualified right. So there's your first mistake, Jim. And saying that Australia is a cradle of free speech, if you are a gender critical woman or a lesbian or a gay man, I don't think you would find it a cradle of free speech, particularly not in the state of Victoria. And I know whereof I speak. I'm not an Australian, but I lived there for a year. I'm in touch with friends. I'm in touch with LGBT Alliance Australia. They're engaged in a big battle against the idea that every child who has gender dysphoria must be told that they're trans. And if it's suggested to them that they're perhaps lesbian or gay, then their therapist can go to prison.
Victoria, by the way, is the only state with a Bill of Rights in Australia.
I thought
we
weren't going to interrupt each other, so let me get. So what I'd really like to say is that human rights are part of a liberal democracy, and I might be on the far left of this panel, not difficult, as everyone else seems to be quite right-wing, with the exception of Claire, but I believe in liberal democracy, and human rights are a protection against majoritarianism. They are for individuals. And I can't really comment on Australian jurisprudence, but they're not at a level of abstraction in the domestic systems of the United Kingdom. For me, as a lesbian and a gender critical woman, human rights have become incredibly important in the last couple of years. My Article 9 right to free speech, to freedom of belief, my Article 10 right to freedom of speech. We've got Maya Forstater with us this evening. Maya wouldn't have won her case that has protected so many gender critical men and women from losing their livelihoods if we weren't part of the ECHR and we didn't have Article 9 and Article 10. When I chaired the Human Rights Committee, the Conservative government were trying to get rid of the Human Rights Act and toying with the idea of leaving the European Convention on Human Rights and wanting to bring in a British Bill of Rights. Now, I believe in evidence-based policy making. The Conservative government set up an independent review of the Human Rights Act, which took evidence across the country during COVID. Actually, it managed to do it, although I have some sympathy with your views on COVID and the COVID restrictions. And this committee came to the overwhelming view that the Human Rights Act was working really well and that really it needed a bit of tweaking. And the Tories ignored that and went ahead with their own Bill of Rights, which they eventually had to ditch because there was such overwhelming opposition to it. Because their Bill of Rights, key thing about human rights is they're universal. Everyone has human rights. Even if you're a bad person, you have human rights. You have human rights if you're a refugee. You have human rights if you're a TERF. That's the joy of human rights, their universality. But the previous Conservative government wanted to take certain people out of the protection of human rights, refugees, asylum seekers, no doubt in due course people with whom they disagreed. So I think human rights at their best constrain the powerful. And just to come back to you on the point of elected judges, where in the world do we have elected judges? Oh yes, the United States of America, a model of a functioning liberal democracy.
I said nothing for elected judges. I don't know where that's coming from.
I don't think so. Well, you said that...
I said I don't want unelected judges making decisions.
You don't want unelected judges. Well, I don't want elected judges
I want parliamentarians, elected people.
Parliamentarians do make decisions. So let's take the example of the United Kingdom Supreme Court's decision in the For Women Scotland case about the meaning of sex in the Equality Act. The Supreme Court has declared that that is the law. If Parliament wants to change the law in the United Kingdom, then Parliament will be able to change the law. But if the law they change it to doesn't comply with the Human Rights Act, then there could be a declaration of incompatibility. So I might be a Scottish nationalist. I'd like to see an independent Scottish Republic with a written constitution. But by God, free speech would be at the heart of that after experiences with some of my dimmer colleagues in the SNP over the last few years. Much as that is my direction of travel, I actually think the British system has a lot to commend it. Our Supreme Court sits there, but we also have Parliament. The idea that Parliament should be supreme over everybody else is quite a particular political viewpoint, because if Parliament is supreme over everything else, then majorities will rule. people like me, lesbians wouldn't have equal marriage in this country if Parliament had ruled at the relevant time.
Well, they do in Australia.
It was the legal system. It was our membership of the European Union and our membership of the ECHR that pushed that forward at an earlier stage. Yeah, of course they do in Australia now, but I'm talking about when it was brought in. You know, lesbians have only had the protection against discrimination in the United Kingdom for 20 years. Trans people got it before lesbians, and that came as a result of our involvement in international human rights instruments. So I'm all for them.
Okay, so we've heard, I think, two fairly conventional defences of human rights. We've heard one very jaundiced assault.
I'm not against human rights. I'm against judges deciding what human rights are.
Okay.
There's a big difference.
Yeah. David, let's come to you. Having read and listened to some of your work on human rights, one of your central criticisms of the way they're used, invoked, is that they may once upon a time have been a bulwark against state overreach, protecting individuals, particularly minorities, vulnerable people. But in the last decade or so, they have almost been turned on their head and are now used as an instrument to impose the state or international body's will on recalcitrant individuals.
Yeah, well, if I can it's quite handy having everybody sort of air their views in this way before I speak, because I think what I would like to bring across to you is really that as soon as anyone starts talking about human rights, they instantly get into a debate about what the content of human rights really are. They stop talking about, in other words, about law, and they start talking about ideals, principles, values. So what they're doing really is having a political discussion rather than a legal discussion, right? They're not really applying rules. What they're doing instead is having a debate. That should tell you something important, which is that human rights aren't really law as such. They aren't really to be understood as a kind of system of rules that a judge can apply to resolve a dispute. Rather, what they are a set of principles. And once you have a set of principles, that's just an invitation to discuss matters which are effectively political. So, let me try to kind of go back a little bit into the history of the development of human rights law to kind of put some meat on the bones of what I've just said. So if you go back to 1950, 1951, the conception of human rights was this was a set of rules that were going to constrain what states could do, for the obvious reason that we'd just seen, or the continent had just witnessed unspeakable crimes, mostly driven by governments. And the idea was you create rules which prevent governments from doing those sorts of things in the future, right? So you have, for example, a prohibition against torture, which means, that's an absolute right, the state must not torture people, right? And there are very few people in the world who would disagree with that principle, right? So that was the original conception of human rights law. It puts a kind of a barrier around what the state can do, right? However, as time went on, rights became, the kind of technical word that lawyers use for this is positivized. What that means is, instead of simply being constraints on the state, they became a reason why the state ought to intervene in interactions between individuals in society. That started off in a very, very small, uncontroversial sort of a way, as the European Court of Human Rights began to rule, for example, that in a family law dispute, so for example, when a couple are divorcing, or when there's a dispute about inheritance, legal aid ought to be provided to the disputants as a matter of the right to family life, which is Article 8 in the Convention. Another example would be, if someone has made an allegation against another individual, they've been sexually assaulted, the state has a duty to investigate that allegation. Right? And again, very uncontroversial. I think there are very few people who would argue against that. But as soon as you open that door, you start asking yourself, well, what else ought the state to be doing? in the interactions between people in society, right? So not, in other words, how should the state be constrained, but what should the state do, right? So as the years go on, the European Court of Human Rights begins to rule that states should take a more and more active role in pursuing effectively social policy through human rights law. And a great example of that, very pertinent in regards to kind of recent discussions about sex and gender, particularly in Scotland, obviously, is the case of Goodwin in the United Kingdom, where the European Court of Human Rights found that because at that time, the time the case was decided, there was no concept of a gender recognition certificate in the UK, the state ought to create a framework by which people could change their gender and have that officially recognised in law. Right? So the state ought to take, in other words, positive action in order to change society through the mechanism of human rights. Fast forward another 20 years, and you have the European Court of Human Rights deciding that the state has a duty to protect the population from the effects of climate change, because since climate change has an effect on human life, right, human health, that has an effect on the lifespan of elderly people, and can constrain, therefore, their ability to have interactions with their family members, for example, their grandchildren, and therefore it's a violation of their rights under Article 8, the right to family life. So human rights becomes, in other words, a mechanism through which the state does things, right?
Do you want to just briefly describe what happened in that case, just in case any people who don't know?
The climate change case?
Yes.
So, well, basically what I just said, a group of Swiss women, there were different, there were kind of conjoined cases, so a group of Portuguese appellants and French, I think, as well. But the main group was a group of elderly Swiss women who argued that because the Swiss government wasn't doing enough to protect them from the effects of climate change by reducing carbon emissions, that was affecting their ability to have a family life because they would die earlier, effectively, is the argument.
No, it was they couldn't go out and socialise.
They couldn't go out, it was too
waves.
hot, that's right, yeah.
Quite important if you're an old woman.
Yeah, sure, but the point is, whether you agree or disagree with that, the point is it's placing an obligation on the state to do something, right? So it's not the state isn't allowed to torture people, it's rather the state must act to reduce carbon emissions, right? The state has to actually do something. So, okay, that's the way that human rights law has developed, right? So it's no longer a constraint on state action, it's really a question of what ought the state to be doing in terms of the policies it should be pursuing. As soon as you start asking that question, you're no longer asking questions really about legal principle or the application of rules. You're asking political questions that are deliberative, that ought to be decided by Parliament. Ultimately, of course, that may result in the passing of legislation. But the actual debate itself at the level of principle is one of policy, right? It's one of politics. It's not a matter of law. And once you kind of therefore open the door to kind of positivization of rights, to give you another kind of classic example of this, you get into a situation in which different individuals in society have competing claims on what the state should be doing to help them. A great example of that, again, I'll keep on the issue of kind of sex and gender and freedom of association, is that in a dispute between, let's say a group of lesbians decide they want to create whatever, a campaign group, right? Or even let's make it more neutral than that. Let's say just a lesbian community group, right, who are just going to, like a social group. And they want to exclude men, trans women, so-called men, from attending, right? Perfectly legitimately. They are, in doing that, exercising their right to freedom of association, right? But then on the other hand, you will have trans women who would argue in the exercising of this kind of exclusionary policy by this community group, the trans person's right to freedom of discrimination is being violated. So you have these two competing rights claims, right? You've got freedom from discrimination of the trans person, and you have freedom of association with the group of the lesbian association. And then you have no way of resolving that dispute except through a political decision. The decision about which of those rights wins is not a matter. I know you will say that there are rules that can be referred to, but when courts so-called apply the rules, what they're effectively doing is deciding which of those rights claims is the most important, which should have priority.
That's simply wrong, because the whole point of the Supreme Court decision is its statutory interpretation by the judges of the Equality Act passed by Parliament, which doesn't give trans women the right to self-identify into the category of woman. And so this actually disproves your argument, because Parliament has resolved this tension. Parliament looked at all the arguments when it brought in the Equality Act and resolved the tension. Then we had trans activist groups for years misrepresenting the law. I'm afraid, I'm very ashamed to say, the Scottish courts getting the law wrong, and then the UK Supreme Court got the law right and applied the principles of statutory interpretation. So that wasn't a political decision. That was the court was interpreting the Equality Act, which is a political decision, but was passed legitimately by Parliament when there was a Labour government. Thank God we've got the Equality Act. Thank you to that Labour government. But I think lots of Conservatives would now be very keen to support the Equality Act. So it's something that kind of, but it disproves your analysis. I think this is very important.
Can I come back on it? So I'm being very careful. Maybe it was about to use that example. I was speaking really hypothetically about that scenario. I wasn't talking about that specific case, because you're right, that's a case concerning statutory interpretation, but it's not a Human Rights Act case, right?
No, it's not. Although the lesbians put forward human rights arguments, and the court had a nod at them.
Yeah, so to use a different example, to use a slightly, to make the same point, but in a less, let's say, sort of politically charged example now, would be civil rights disputes in the United States in the 1960s, right, where you have, a shop owner who wants to exclude black people from his shop, and then the right of people to freedom of discrimination in order to access goods and services. So perhaps that's a better example to illustrate the points I want to make, which is you've got these two rights claims, right? You've got the freedom of association, you've got the right to freedom of discrimination, and the decision about which of those rights takes priority is a political decision. It's not a legal decision, because it's a question of what you value, right? Do you value the freedom of association of racists, or do you value the freedom from discrimination of an ethnic minority? That's a political question. It's not a legal question. That's a matter that's for an elected body to decide. It's not a matter for a court to decide.
But some people would very much disagree with that, because they would say that there's fundamental rights, and they would say fundamental rights, it's fundamental, it's a sort of moral imperative. You go back to Aquinas or something and say that it's a morally right that people whose skin is black should have the same rights as people whose skin is white and shouldn't be discriminated against. So then there are some fundamental principles, and anyway, I don't want to dominate the conversation.
Claire, how do you respond to David's argument, and I think we heard a similar argument from James too, which is that there's something slightly artificial about invoking these abstract frameworks when trying to resolve what are fundamentally political disputes. And maybe it's kind of politics by proxy. We're very much seeing that with the fight over the Supreme Court's judgment in the For Women Scotland case. Maybe that's the arena in which these political battles are fought. But it seems like a slightly artificial arena. What they really are, these conflicts, are political conflicts. And for that reason, we shouldn't entrust, to use Jim's phrase, unelected judges to resolve these fundamental political disputes. It really should be a matter for Parliament.
Yeah, well, we don't really entrust, unelected foreign judges to resolve these disputes for us. I think that's why, it was so important to start the discussion, as I did, by distinguishing the different meanings and senses of human rights, because I think, there's something in many of the points that David made, but they don't all relate to human rights in the sense of the human rights that are protected, for instance, under the Convention, and which are protected by the European Court. But nonetheless, those kinds of dilemmas and conflicts are then mobilized by opponents of the European Human Rights, European Convention and the Court as critiques of the Court. So, as soon as you have slippage between, issues which reflect perhaps inherent, challenges and weaknesses in rights discourse necessarily, but you allow those to be mobilized as critiques or as the basis for critique of a specific court and regime, then then you have analytical incoherence, and you have political, in my opinion, disaster, because people are confused. They can see that there are issues and problems with rights discourse, but they then think that that's the fault of a specific institution, which I think remains as one which has a valuable and valid function in the context of the European continent. And it's really important to remember that the European Convention is a very limited set of rights. They're civil and political rights. The content is pretty circumscribed, notwithstanding the doctrinal developments that David has mentioned in terms of the development of positive obligations, the principle of effectiveness of human rights, the broader principles of interdependence and indivisibility of rights. All those things have evolved in the last 50 years to try to, restrict the limitations of arbitrary limitations on human rights that typically affect the most vulnerable, and which I think are probably offer important protections to all of us in this room. Those things have developed for good reasons, and there's further limitations in what Strasbourg can do by way of the idea of the margin of appreciation, which allows different countries in the Council of Europe to do things differently with reference to local circumstances. Right, so there are many protections, safeguards, restrictions on what Strasbourg can tell us to do or not do. They remain very important. Where I think there is a valid point is about rights discourse. And I think the unfolding of rights discourse, and of course what happens in the legal sphere and with reference specific instruments, is not irrelevant in that context. But what has happened with rights discourse is that we do have a number of probably interrelated but separate trends in rights discourse. One of those, for instance, my thing here keeps dying, is proliferation of rights. So, we do have many more rights now than people ever foresaw in 1945. We have not just the civil and political rights, we have economic and social cultural rights, we have environmental rights, we have rights in the context of climate change. We have, and it's become a much denser, thicker environment legally in terms of the number of different rights. Of course, people's identities and the heads of the number of protected characteristics has also really multiplied. So before, it was sex and race and religion, and now, people, according to their identities, have, and in many cases validly, developed claims based on other characteristics. We have, specific instruments on disability, on children, on, different kinds of ethnic minority background, and we have fragmentation in society around all those things. So when you add that together, and all the different equality-related demands and protections, along with the multiplication of rights, you're getting a really complex picture that increasingly judges, not to mention politicians, not to mention people in society at large, really have problems to navigate. And I'll give one example, concrete example of how this can play out. In the context of the European Union, recently, the EU enacted legislation where they wanted EU-based companies, large EU-based companies and large companies operating in Europe to essentially have a internal management system in relation to human rights, managing their human rights impacts and preventing human rights abuses in the supply chain. What was the scope of the obligation on the company? Well, the scope, as a result of lobbying in Brussels and do-gooding intentions in the European Commission, the scope of the obligation for companies was defined with reference not just to the European Convention on Human Rights, but this really broad swathe, that ran to a page of instruments, some of which don't even establish legal obligations for governments. So companies then were supposed to implement this very dense set of rights, each of which is quite indeterminate in its scope, across their whole supply chain globally. So you end up then with a duty on a company, which in any case doesn't have the infrastructure really, or the know-how, or the specialist expertise, and no one ever, the function of companies in society is not to deliver rights for everyone, was then supposed to be able to make these finely balanced judgments in third jurisdictions, Saudi Arabia, China, about how to balance all these different rights obligations in their own activities and with suppliers. So you have, and then courts in the EU were supposed to enforce that and secure tort damages for victims who claimed that they had been, suffered harm because of the result of the company's failure to appropriately manage their human rights responsibilities. So you have a tissue which is completely indeterminate and actually, I would say, incapable of judicial enforcement, right? So that is the place that you can end up as a result of rights proliferation, kind of gold plating of expectations about what rights can deliver in for one group of people in one scenario, and that is where we cannot go. And I think if we look at what we see in terms of, for instance, human rights impact assessments in the Scottish context. Now, and we have also had a discussion about incorporation of additional instruments in Scotland. We've incorporated the UN Convention on the Rights of the Child. We already have the European Convention incorporated via the Human Rights Act. On the table was legislation to incorporate Economic Social Rights Convention, disability, LGBTQI+, which doesn't even exist at the UN level. And then, public authorities in Scotland would have had legal obligations somehow to deliver on all of those things simultaneously, notwithstanding, as we know, that they do conflict necessarily, and that each of those conflicts needs to be negotiated and figured out in ways which are very demanding for specialist judicial organs like the Supreme Court. Look how difficult it was for the legal system in the United Kingdom just to figure out what the interaction was between trans rights and women's rights in a very narrow set of circumstances. So if you try to do that, for all groups, for all rights, simultaneously, you get a burden on public authorities which is not possible to sustain. And I think if you look, for instance, at, as I say, human rights impact assessments that Police Scotland and others have had to produce, people who don't have a legal background, who are not specialist lawyers, who are prey, like all of us, to lobbying, etc., by others, you can get consequences which are not supported at all by the original instruments which they derive from. They're completely disconnected.
So we've ended up in crazy town.
Yes.
But you would say, Jim, I imagine, that it's inevitable that we'd end up in crazy town.
Well, I just want 4 brief points. Firstly, I agree with Joanna on the 4 Women Scotland case. It was bog standard statutory interpretation. I think they got it right. What I would say is, when I read the case, it surprised me that the top court didn't make any use of the Human Rights Act Section 3 reading down provision. So you don't have a written constitution, so the only way, you can't strike down laws, you need a written constitution to invalidate laws. And what Britain did is they basically copied the New Zealand Statutory Bill of Rights. I was in New Zealand, I lived there. And so how do you deal with, if you can't strike down laws, what do you do? And they have these provisions. The British one basically copies the New Zealand one. It says, you judges do everything you can when you're reading these other statutes to give them a rights-respecting meaning, right? And it turns out that in this case in Britain called Guyton, the judges said, well, we can read words into the other statute, we can implicitly read words out. There's even a quote where they said, we can ignore the clear intention of the enacting parliament. When the Australian courts looked at that, they laughed. I'm not making this up. The New Zealand courts laughed. The Canadian court said, this is crazy. How do you have a rule of law regime where the courts can take a clear statute and give it a different meaning because they think it's right respected? Now, I have quickly looked up, and there's lots of academics who think that the Human Rights Act will be brought to bear against this decision. I hope it's not. I like that case because it's what judges should be doing. Second point, anyone seen the Spike Lee movie? There was this famous American director, and he did a movie called Do the Right Thing. And here's the problem. People disagree. People you'd have a beer with. And you can't resolve disagreement by saying, we'll do the right thing, because all of us disagree. Nice people disagree. So you need a procedural rule. Do you know how judges on the UK Supreme Court or the American Supreme Court or the Canadian Supreme Court or the Australian, you know how they resolve their disagreements? They vote. You can have 5 worthless judgments written by law clerks that are inane, and that beats the 4 fabulous, insightful judgments that make reference to the ICCPR and John Stuart Mill. You always need a procedural test. You know what the difference is between Parliament doing it and 9 judges? It's called the size of the franchise. And the implicit understanding that some of my friends up here bring to bear is, if you have a law degree, your moral antennae vibrate at a better frequency than that of plumbers and secretaries. It's a real problem. The other thing I would say, Joanna is flat out wrong about Australia. The scope for lesbian women is far better, free speech scope is far better in Australia, except in the state of Victoria. It is a mess.
It's a big state.
It is also the only state of Australia that has a Bill of Rights. I'm not making this up. It has done nothing for them, because ultimately the political system in Victoria is broken. Although Moira Deeming just won a big defamation case recently, and I'm telling you, when we do free speech events in Australia, one of our biggest support groups are lesbian, because in a way, I mean, who would have guessed 15 years ago that anyone would pay attention to some of the claims being made by the transgender lobby? I don't know what happened. I'm staggered. And then the last thing I would say about the European Convention and the European Court of Human Rights, it's all being glossed over as if this 1950s document is only growing a little. It has expanded massively, and it's been done using an interpretive approach that treats it as a living document. That's the exact words, isn't it? Living document, living instrument. That is a slogan that has no real meaning. It's a piece of paper. It's not alive. A living document interpretive approach just means that the people at the point of application, the judges, are imposing their views of what's rights respecting. Again, a big problem. Now, if we said there's a 1950 statute that was passed, when Churchill first came in or when Attlee hadn't quite left yet, and someone said, I want to repeal it, no one would think twice about it. But you invest it with some sort of higher value because it's an international law document. I don't think there's any doubt that Britain has to leave the European Convention on Human Rights because it's unsalvageable.
Okay, on that controversial note, we shall go out, and I'm sure this will come up on the panel, but let's go to some questions. Gentleman at the back with his arm up.
Hi, Stuart Waiton. I'm an academic at Abertay University. Joanna said she was left-wing. I've always considered myself left-wing, although I don't really know what it means now. But part of what it would mean was that you'd have this idea of a man of the people, right, or woman of the people, and the idea that you trusted people, I think, if you were left-wing. That's what I always thought, and that you felt you were part of the people. That was how I always thought about left-wing. And then you said human rights are good because they protect you from majoritarianism, which sounds like the people. Now, I'm involved with the Scottish Union for Education, and our strapline is education, not indoctrination. And one of the things we've come across in schools is, I would say, something similar, which is that it's a kind of protecting children from the majority. So you have trans ideology now in schools because you need to be inclusive, right? Because you're protecting a certain group from what they see as the majority. You teach children now about white privilege and that they have white privilege and so on, because you're trying to protect people from the majority. And what I see in schools and all institutions pretty much is what I would describe minoritarianism, which appears to me to be a powerful force which is authoritarian, doesn't accept criticism. And so rather than me, when I hear people defending human rights, I often feel that they are minoritarian authoritarians. So I'd like to throw that back to you.
Yeah, you want to take one question at a time, respond to it, or should we take a few more?
Take a couple and then
We'll take two more and then we'll...
probably should forget what the question is.
Yeah.
Yeah, hi, Andrew. I'm an FSU member and I'm also part of the Citizens Commission on Human Rights International. So as a worldwide organisation, we've closed down psychiatric hospitals, had psychiatrists jailed, etc. Would the panel examine the erosion of human rights from a mental health perspective, where psychiatrists have continually eroded people's human rights, their free speech, their right to their own sexual orientation, and even just having a look at October the 9th, where the World Health Organization and United Nations organised an event where these mental health laws, which are focused primarily on compulsion and containment. And in this piece of paper here, I have several names of Scottish people, some of which have been locked up in psychiatric facilities since 2010 based on autism, intellectual disability, or they claim they've got ADHD. So going back to psychiatry's Germanic creation, and given the fact that most of them should have been hanged at Nuremberg, but were allowed to escape into the institutions of the world, wouldn't mental health be a good place to concentrate on a re-establishment of human rights and the right to free speech, the right to be yourself, as many in the LGBTQ+ community have discovered from their protests throughout the decades. And obviously now they're not seen to be, as they never were, mentally ill or mental disorders.
Okay. One more question and then we'll come back to our panel. Maya.
Thanks. Maya Forstatter. I'm the CEO of a human rights charity for my sins, Sex Matters, and we take that quite seriously. We have found the human rights framework useful in thinking about, trans rights versus women's rights. What does that really mean? What really are trans rights? What rights are they asking for? It's the right of freedom of expression to wear what you want and call yourself what you want. And how, when that right of freedom of expression comes into conflict with other people's rights, what do you do about it? So conceptually, we found it quite a useful thing. But the odd thing I've noticed is our charitable objects, which are the human rights charitable objects, they say basically you support the Universal Convention on Human Rights, are almost exactly the same as Stonewall's, and almost exactly the same as Liberties, and almost exactly the same as LGB Alliances. We all have the same template, and we can't even sit in a room together. And I would love to sit in a room together with them and just say, what are the rights that you think you have, and what are the rights that we think we have, and can we at least work out where your fist is hitting my nose? And if we have to do that in court, we'll do it in court. But it seems like we ought to be able to at least talk about that stuff conceptually. And so my question is really, why has the human rights discourse beyond going to court? I like going to court because people can't run away and say they're offended and not have an argument with you, but it's expensive. Why with these organisations with this human rights framework can't even sit in a room and work out what their conflicts are?
Okay, so let's start with the challenge that Stuart made to you, Joanna. You're an authoritarian minoritarian.
Well, it's just rubbish. And I find it extraordinary that people who are gathered together as part of a free speech union are cheerfully clapping, getting rid of the rights that mean that we are able to have this discussion, that we're able to be here this evening.
You're not getting rid of the rights.
No,
you're getting rid of judges overseeing the rights.
You're wanting to get rid of the Human Rights Act and the ECHR. But I'm going to answer Stuart's question.
Yes, there was. Come on.
Right, okay. Well, I'm not an exceptionalist, and I don't think British rights are better than international rights. We have the ECHR, we have Article 10, we have Article 9. Maya and I will tell you, as we've both been engaged in litigation where we've needed Article 9 and Article 10 pretty badly, they're functioning pretty well at the moment, so be careful what you wish for. But no, I'm not an authoritarian minoritarian, but there's a real problem in our schools, and you know what that problem is? It's policy capture. So one particular minority in our society have captured policy development. The way to challenge the guidance in schools is to use rights, to make sure that all children's rights are respected and that all minority voices are respected. If you get rid of internationally recognised rights, or if you want to make Parliament supreme about everything else, then you're not going to have a sword to use when your rights are challenged. Now, one of the things that the Independent Commission on the Human Rights Act found was that our discourse, which Claire's talked about, our public discourse in the United Kingdom gave the impression that most people who were benefiting from human rights were foreign criminals or terrorists. But in actual fact, when you look at the people who have benefited from human rights legislation in this country and from the incorporation of the ECHR and the Human Rights Act and being able to go to their domestic court, you find that quite often they are vulnerable minorities, people who were losing their welfare rights, the families of soldiers who died in foreign wars because they didn't have proper protective equipment. The Hillsborough people, the Hillsborough victims would never have got the inquest reopened if they hadn't brought an action asserting their Article 2 rights. The victims of the War Boys taxi rapist, they would never have had a proper police investigation and he wouldn't have been brought to justice if they hadn't brought a case under Article 3. So Stuart, where you and I agree is that there's a problem in our schools, the answer to that problem is to use the weapon of the law. There could be a judicial review in which you bring in human rights arguments and other ways of challenging that legislation. But you know, those of us who are veterans of the struggle against the policy capture by gender identity ideology, the Human Rights Act has been a really important tool in our box. And when judges interpret human rights law, they don't just state their political opinion, whether they're a One Nation Tory or a wishy-washy Keir Starmerite Labour person. No, they're drawing on a huge bundle of principles and precedent, so they're not just sticking in what their opinion is. You know, I've sat in Parliament for the last 9 years, and I've looked at the Scottish Parliament. Woe betide us if those people are in charge of making our laws and we have no way of challenging them. Look at the Hate Crime Act in Scotland. That was a majoritarian thing. Is it good? No, it's dreadful law. It's extremely repressive law. It has really regrettable parts in it. And one of the ways of challenging that, or potential challenges through the courts, is by asserting Article 9 and Article 10 rights. So that is why we need checks and balances. You know, if you live in a liberal democracy and you believe in the rule of law, human rights and the rule of law is there to protect individual citizens against the might of the state. This idea of majoritarianism, if that's what you want to put above anything else, then when they come for you, you won't have any protection.
Joanna, you just by definition, that is balderdash. Hang on, you can't let her. You can't just define the problem as if you're on the other side, you're against the rule of law. That is ridiculous. Look, the problem with Scotland was obviously that the SNP brought in legislation. When I was here in the 80s, Scotland had the best education system in the world. And let me just say, I'm 96%, I come from a long line of Scots, Canadian, Calvinist types, you know. But it's an embarrassment what's happened to the education system here. My guess is all while the SNP were in office here. I don't know that.
The SNP have been in office for 18 years.
Yes, okay, so
as a result of majoritarianism and democracy,
well,
which you're
you know
such
how
a
you
big
fix
fan
that?
of.
Here's how you fix that. You vote them out.
I'm very critical of them.
And you know what?
But they got there as a result of an election. That's your thing.
No, it's, you know, you just repeal these bad acts. That's what used to happen in the past. And just on the political spectrum that Stuart brought up, you know, I get called far right. You can't put a piece of paper between my views and John F. Kennedy's. Well, he'd have more hookers in the White House than I would, but, you know, leave that aside. So the spectrum has moved massively. And what a lot of people don't realize around the Anglosphere and the democratic world is the old-fashioned Dennis Healey-like redistribution of wealth, left-wing, they are gone. The 100 wealthiest
not
counties,
in this country.
The 100 wealthiest counties voted for Clinton, not Trump. In Canada, wealthy inner cities overwhelmingly vote left. In Australia, Boris Johnson did not win the rich inner city London boroughs, I'm telling you. So the left-wing parties have become the sort of Keir Starmer, progressive human rights types parties. And that, in a nutshell, is why reform is moving up, because there's a big hole in the political spectrum. So if you don't like something, spend a few Saturdays, join a party and fix it. But don't run to judges, because if you think that you can't do anything if the parliamentarians decide in a way you don't like, well, you can. You can vote at the next election. If judges declare your timeless right and you don't like that timeless right, you can't do anything.
Okay. David wanted to come back in response to what Joanna just said.
Say something that sort of ties all those three questions together, because to sort of, I don't want to kind of rain on Jim's parade too much, but who's the original and best critic of human rights? It was Karl Marx. Karl Marx said, identified this in the middle of the 19th century, right? The big problem with human rights is, if you're on the left, is that they create bourgeois, individualist consumers who are just obsessed with their own property, defending their own interests, and don't think about the wider interest, right? They don't think about the public interest. They don't think about what's best for everybody. All they're interested in is fighting their corner, using, to use Joanna's expression, a sword against everybody else to fight for their own interests, right? That was, simplifying his argument slightly, but that is basically what Karl Marx said.
But my argument said the opposite of that. I said the vulnerable can use it.
But the problem is, everybody can find a way why they're, for some reason, why their identity is being, in some sense, constrained by somebody else, right? You mentioned this. I think I can't remember the exact phrase that you used, the gentleman there. Talking about the psychiatry. I can't remember your name. Sorry. So you said everybody ought to be able to be themselves, and it sounds great. And it was actually I made a note of this because I was actually reading the hate crime strategy of the Scottish government on the way up on the train for a bit of light reading, and. It's forwarded by the senior police officer in Scotland. I can't remember what his name is or his rank, but a very prominent police officer.
Mr. Hardy.
And he said, right, I can't remember the exact phrase that he uses, but he wants Scotland to be a society in which everybody can be themselves, right? Everybody is free to be themselves. Great, we all love the sound of that, okay? So now what happens when you have a trans woman and a lesbian who have competing ideas about, who should be allowed to associate with who is a woman and who isn't? As soon as you get down into the nitty-gritty, the high-minded principle goes out the window and it becomes a fight. It becomes a political fight, right? It becomes a matter of deliberation. And that's why I thought you made a really interesting point when you talked about this need for... Why it's so much more preferable to have people discussing things than it is to litigate, right? We all understand why litigation is necessary, but it's the last resort, right? What we want is political deliberation, as much political deliberation as we can get in deliberative bodies, in other words, parliaments, not courtrooms. It's not that there's no need for litigation.
It's not either or, it's both.
No, I agree with that. But I think what we've got into the territory where it's becoming litigation is almost like the first resort rather than the last, right? So I think we need a better balance, undoubtedly, whether or not we're repealing the Human Rights Act or not. We can set those grander questions to one side. It would be better if we could have more deliberative decision making, I think.
Claire, did you want to briefly respond to Maya's question, which is that if these human rights frameworks are good mechanisms for resolving fundamental disputes, dividing society, why have they proved largely ineffective when it comes to resolving the issue of whose rights should trump whose, sex-based women's rights or trans rights? But the advocates on both sides will pray in aid human rights, but that doesn't seem to have got us very far. And yes, we've had the Supreme Court judgment, although, as it's been pointed out, that was about the interpretation of the Equality Act and Human Rights Act wasn't invoked. But you'd think they'd be more helpful, but the examples you gave does tend to suggest that these disputes are fundamentally political, and to pretend they're about something more abstract isn't very helpful, or it isn't always helpful.
Well, yeah, I mean, I guess I don't accept fully that, the premise there that human rights have been ineffective in helping to resolve, that particular, clash of rights to the extent, that isn't a misnomer in itself. Because I think part of the problem here is that, which has been brought out by Sex Matters and others, not through the Supreme Court litigation, because it wasn't, mediated actually through legal human rights at all. It was purely resolved as a matter of, domestic equality law. But, it's not really a clash of, so I don't accept that human rights failed there, because human rights weren't really in issue, in the UK. But human rights can and ought to help to resolve that clash of rights, because I think the point there is that rights claims have been made in relation to, trans rights, which are not human rights claims. They're rights claims in the sense of rights discourse. They're actually not valid legal claims, because there are no legally defined human rights of trans individuals that support the claims that are being made for them. There's no right in Goodwin or anywhere else which goes as far as people have said. So there's just falsehood around in that discussion, and actually a better informed human rights-based discussion, I think, could have clarified that from the outset and help people understand, not everything that you want in the name of your human rights will be given legal protection as such. The right to, an adequate standard of living doesn't mean you get a swimming pool in your back garden. The right to a, legal recognition of your gender identity does not mean you can go everywhere and do everything that you want to do as a trans person.
Who draws those lines?
Well, I think you can have lines drawn at different levels. That could well be a discussion that's had in the United Kingdom Parliament, and we make our own decision about how to balance those. I think you still, national legislatures, national courts can get things wrong. We know that has happened in the past. Nationally, we can go down wrong roads. Nationally, we can overlook certain minorities. The rights of people in mental health institution in most countries in the world and in Europe for so long were, overlooked and still are. So we do need international institutions to provide that course correction, that can do the programmatic monitoring, in relation to torture, places of detention, children, etc., that can pick up where nationally things and people are being overlooked and, downtrodden and having their most fundamental rights and dignity not respected. So I think we do need those safeguards beyond the nation state. They don't have to be always judicial mechanisms, and they're not, frankly. In many cases it's expert bodies. It might be mixed bodies of doctors and lawyers and health professionals who are doing that important work. So, that's why I think we still need the mechanisms. They don't always have to be judges. And the Human Rights Act, just to go back to that point, I think, was never intended and does not necessarily have to be a mechanism for, the substitution of democratic with judicial decision making. A more robust approach to declarations of incompatibility, where political parties that are saying we're legislating in this way, it actually doesn't accord right now with what Strasbourg has decided on a specific thing, but that's okay. This is what we think about how this clash of rights should be resolved here now in our country, and these are the reasons why, and this is why we think the rights should be balanced in this way here at this point instead of at this point over here. Own it, and defend it in Strasbourg instead of just saying we can't be part of the conversation at all.
Okay. So let's have three more questions, and then let's sum up and go to the pub. But can someone ask whether or not we should leave the European Convention? Because I think that David and Jim's answers may surprise you. They, when I talked to them about it, they've surprised me by throwing up some really interesting practical obstacles to doing that. But anyway, three more questions. Gentleman in the front row. Sorry. Yeah, you got the mic. Sorry, you be next.
held into saying what you want me to say
Sorry.
there. It's okay.
You're invoking your Article 10 rights there. Yeah.
Sebastian Monte, I'm a lecturer at Abertay, and also part of the Scottish Union for Education. I just wanted to, maybe I'm stating the obvious, but has the expansion of rights that you've talking about conflated what it is to be human materially with a kind of perception of what it is to be human, and so conflated material with a perception or identity, so with the mutable characteristics, with an expansion of identitarian issues. And so the best example would be sort of the joining of the LGB with the rest of the numbers. And so you're conflating two competing ideas of what it is to be human. And so maybe the middle ground is to row back and to go back to protecting free from harm for immutable characteristics, and to maybe set aside the perception of what it is to be human, because that can't be legislated for.
Okay. We'd better have a question from a woman now, because genitalia is obviously very definitive when it comes to defining what you are as a human. Yes, Penny.
Have you got a mic?
I think she'll need the big one. Oh, okay.
I'm sympathetic to the use all methods, and I was very excited by the Supreme Court decision. But I'm also wondering, isn't there a danger that it's corrosive? I mean, we have to think very seriously about the corrosion of politics and the meaning of rights. And I'm thinking particularly, I go into schools quite often, posters in schools everywhere with the 54 or 45 UN Convention on the Rights of the Child, which tell children they've got a right to get information in lots of ways, they've got a right to an identity, they've got a right to have their thoughts and beliefs, to choose their religion with the help of their parents as a sort of subsection. I think, what are we educating young people in Scotland to understand as rights at the moment? Because I think we're confusing them profoundly. And it creates a culture which lets the political class off the hook, because they discuss everything in terms of human rights. And then our agency to ask them to deliver and to ensure they deliver is undermined by the fact that that dialogue is at an incredibly abstract level. So what about politics? Isn't there a danger?
Okay. And gentleman in the front, we'll just wait for the mic.
Hi. I, at risk of maybe changing things rather late in the game here, I was hoping that we could bring this discussion back to free speech, okay? And so it seems that most of the debate has been, at least to my mind, about what is the site for the assertion of human rights? Is it in the courts or is it in the parliament, okay? And I think everyone agrees, well, this checks and balances is somewhere in between, something like that, but blah, blah. But could we, and most of that's been with reference to gender questions. And I wonder if we could bring it back to free speech, because it isn't even clear to me in the terms that we've already been discussing where free speech lies. Is it in the courts? Is it in Parliament? Is it a human right, or is it a positive right? You know, I mean, so could we just bring it back a little bit to the terms?
Yeah. Throw that question to Jim. I know we've disagreed before, both about the pros and cons of remaining in the European Convention, and also whether free speech could be better protected if we withdrew, passed a Bill of Rights, included in that Bill of Rights something like a British First Amendment. And you've been quite sceptical about that as being a way to better protect free speech.
So I got to be brief, right? Because I can hear the call of alcohol. And I just about died, when Claire was speaking, and she said, oh, we need to rely on medical experts. And I went, oh my God, fuck. After 2.5 years of COVID, the last person in the world I'm going to rely on are medical experts. Kill me, please. But leaving that aside, so look, rights are not absolute. Joanna got this right at the beginning. you're always in the business of sort of shading rights and limiting them. It's again a question of who's going to do the limiting. I'm going to make this empirical claim. I can back it up, but if you look around the Anglosphere common law world and you ask judges a free speech question and they're having to weigh that free speech question up against an equality right, they favor equality rights. Judges do. I know, there's obviously we can point to exceptions. I'm going to say this again. Australia has no Bill of Rights. There is more scope to speak your mind in Australia on hate speech issues, no one, it's an embarrassment, Britain, that the police go around handing out one of these non-legal sort of notifications. What is that? This is the home of free speech. It's an embarrassment. So you're always in the game of limiting these things. And judges, as a group, I generalize, will lean towards equality over free speech. If you want to protect free speech, you have to do what we have to do in Australia. You have to repeal the goddamn public order offenses and the weird statutes you have here that are embarrassment. And let me just finish with this. Take a right I don't care that much about, the right to abortion. I'm indifferent, right? So I picked that one. Every country in the world except the US, they resolved it through the back and forth compromise of the elected legislature. The Americans decided it through Roe v. Wade in 1972. And it stayed there forever because people who are on the losing side in a democratic thing say, well, I can work for a party and we can change this. But if you're on the losing side in the US, you had no remedy except to appoint a judge who might change it. 25% of Americans tell pollsters they vote for the president based on the kind of judges he's going to appoint. And you know what? How many people in this room know that since Dobbs, the case that overturned Roe v. Wade and sent it back to the legislature, how many people know that the number of abortions in the US has gone up? Not down, up. That's the New York Times, by the way, not me. And so, why can't we trust the elected legislatures to resolve these sorts of problems? Of course you're not going to be. If you think you're going to be on the winning side of every issue, you're Robert Mugabe. You cannot be on the winning side of every issue. You're going to win some and lose some. And the people who are on the other side, they feel just as strongly as you do. And that's, I'm a Churchillian about democracy, who Churchill, by the way, represented a Scottish electorate for a while.
Not for long.
Not for long, but he did. Great man, my pick for the best figure of the 20. He's flawed, but great. But at any rate.
I agree with that.
Okay, well, there you go. See, we're going to have a nice, fun drink.
But he didn't understand the Dundee working class, and he had no business in this city.
No, he didn't. He made a lot of mistakes. He made many mistakes, but, we would have lost the war if he hadn't been there, I think so.
I think that's probably true. Yep.
So anyway, you've got to get out and do something and fight for politically. How many people know that about a third of cases on appeal are successful? That's a generalization about the common law developed world. So when Claire says, well, if you don't let, the top courts in Britain make mistakes, all courts make mistakes in the sense that people aren't going to agree. If we had a super Supreme Court of the UK, they would overturn about a third of the decisions. And you know that as a matter of practice, because if you paid people £600,000 a year and they never overturned anything, they'd be out of a job pretty quickly. So we know going in that these are borderline calls. Some of them are 5-4. If a judge dies on the way to court and another judge replaces, does that mean your timeless right is flipped? It's now 5-4 the other way? These are big, big problems. And that's why you have to have a little bit of trust in your fellow citizens. Making these, it's all very well and good to point to the law, but what you're really pointing to are flawed people who have a law degree. Why would you think a legal degree makes you a better moral person? I spent years in a big law firm. You know what all we did was tell jokes about lawyers before we gave clients the bill. What's the difference between a dead lawyer on the highway and a dead snake? Skid marks in front of the snake. Right? There's lots of them. We can tell lots.
You should put the Supreme Court back in the House of Lords.
I would do that too.
Absolute nonsense.
David.
Utterly retrogressive nonsense.
Do you want to just briefly say what the biggest practical obstacle is to leaving the ECHR before going on to? I think.
But no one asked that question.
I know. That's why I'm going to ask it.
Answer the questions that people have asked.
Yeah, let's. So deal with the questions people asked first.
Well, I don't really have much time. Okay, well, you were nodding enthusiastically.
No, I was just saying I just agreed with that gentleman. I thought you made a very good, helpful observation that I liked.
Well, that's a bit boring.
I don't have anything to add, but on the freedom of speech. So the American founders knew what they were doing, because they didn't, when you look at the text of the Constitution, right, the First Amendment, it doesn't create a right to freedom of expression. What it says is Congress is not allowed to make a law which abridges freedom of expression, right? If they made a rule, you're not allowed to do that. What we did was we created a right to freedom of expression, but it's subject to all these caveats, what's in the public interest, blah, blah, blah. So if you look at the European Convention on Human Rights, it doesn't create a rule, it just creates an opportunity to discuss what's in the public interest, when should speech be constricted, in what circumstance. You're talking about, again, political questions. So if you want to protect freedom of speech, if you wanted to have a British Bill of Rights that somehow mirrored what is achievable in America, you never really could, because of the way the Constitution works is different. But you would create a rule something like that, right? We are never going to create a law that abridges freedom of expression. That's what you want. You don't want a right to it, you want a rule which says no, you're not allowed.
But even in the US, until the beginning of the 20th century, the First Amendment didn't do much to protect free speech.
No, I know, yeah. Well,
And it still doesn't.
Anyway, Joanna,
Right.
did you want to respond to
something
anything
really
James said?
strange is going on here this evening, because you came here to discuss free speech, and there's a big move here to get us to discuss leaving the ECHR. But you know what? You've lost that argument, boys.
Okay, no one's
the best chance you had was in the previous Parliament, and the Tories didn't get their act together, and now the British people have elected a government at Westminster that supports the ECHR, and the Scots have elected a government at Holyrood that supports the ECHR. So it's a bit of a waste of course you can discuss it as much as you want, but that's not what I came here to discuss tonight. I came here to discuss the importance of free speech. So to get back to the gentleman in the front row's question who asked about free speech, what I want to say about it, why I think Article 10 and Article 11 are good, freedom of speech and freedom, the right to protest, is because they are qualified rights. So I can't stand outside your house and yell abuse at you and bang on the window, because obviously that's really going to upset you in your home. So of course that's not part of the right to freedom of speech. But what's really good, so it's a qualified right, but what's really good about the Article 10 and 11 rights is they impose both negative and positive obligations on the state. So that means the state has to refrain from applying unjustified restrictions on the right to free speech and the right to protest. That's their negative obligation. But they also have a positive obligation to facilitate free speech and to facilitate the right to protest. And so that means that's why lots of us have to see people protesting that we don't necessarily agree with, and the police have to be there to facilitate protest. And that is a good thing, because that gives people a voice in their society. So I think what unites us in this room, I hope, is that we all believe in freedom of speech. There's different ways of protecting it, and the gentleman who said it was protected before the ECHR is absolutely right. We could protect it without the ECHR, but I actually think the jurisprudence in Strasbourg has been quite effective, and it's particularly that there is a high degree of protection for political speech, which I think is really, really important. So,
what about Jim's point that given that there will always be a degree of judicial discretion as to which right to prioritise, how to interpret Article 10 and so on and so forth, when faced with a choice, when they have to decide whether to favour equality over liberty, the loyally cast in charge of these Supreme Courts, both here and in Europe, will generally, not always, but generally favour equality at the expense of free speech.
Well, I think that's a very simplistic analysis. Even if you look at our own United Kingdom Supreme Court, it's,
well, I only had a minute.
It's gone.
To be fair to me, I only had a minute. Yeah.
Well, I'm just going to finish my point and then I'll shut up. I think that's a very simplistic analysis. And also I think Jim is shadowboxing. He's forgetting that we're sitting in the United Kingdom at the moment. And if people don't like a decision of the United Kingdom Supreme Court, it can be overturned by our Parliament. So that's why I'm going to be really kicked out of the SNP now. But I actually think the British system has quite a lot to commend it. I'm not saying it's perfect, but it has quite a lot to commend it. But this idea that Parliament should be supreme above everything else, it's a political viewpoint with which I don't agree. And the reason I don't agree with it is I think if Parliament becomes supreme over everything else, then you have the rule of the majority and minorities suffer. Checks and balances are much better. What's that great quote? Maybe it's even Churchill. Democracy's not a great thing, but it's all we've got. Was it Churchill who said that?
No, he said it's better than anything else.
Better than anything else, yeah. So I think the system of checks and balances Well, fine. The system of checks and balances that we have in a liberal democracy, I think, are better than anything else. And I think Marx's analysis about rights was an extremely simplistic analysis. And there were Marxist lawyers who disagreed with them. Think about people like, I think it was at Pashukanis. But anyway, that's going down another rabbit hole.
Okay. Claire, I'm going to give you the last word. And do you want to respond to the philosophical point? And I'm not going to bring up these, leaving the ears. Do you want to respond to the philosophical point made by the bearded gentleman up there, which is that all this discourse around human rights is based on a rather distorted and potentially impoverished conception. We seem to think that the most important things about our identity are the colour of our skin, our genitalia, who we want to sleep with, when actually, philosophically, historically, those are quite trivial aspects of human identity. What aren't we focusing through the kind of prism of human rights on aspects of ourselves which really we oughtn't to be attaching so much significance to?
Well, yeah, I mean, I do think that takes us into, you know, a different and very important discussion about, you know, the extent to which, you know, the fabric of community and political community is being undercut by, you know, long-term structural trends. I think rights discourse maybe has a role in that context, but not, you know, not in and of itself necessarily. But, you know, I am still on the left. I think the, you know, conjunction of rights with, you know, elements of globalization, cosmopolitanization, and migration has got a role in there. You know, they are playing a role in diminishing the basis for we feeling and political community, and that, you know, political communities, and this one, you know, be it Scotland, be it the UK level, needs to reproduce itself and sustain itself and know who we are, what our values are, and, you know, and therefore, you know, how we do negotiate rights clashes and the limits of rights. So, you know, I think that is a big, complex, heavy agenda, and I think the rights discourse has played some role, but I think there are other broader social trends which are contributing, you know, and technological trends which are also contributing to that sort of dismantling, you know, of what it is to be human. And, you know, those are big, important philosophical questions. You know, the loss of religion and so on also has definitely got an important role to play there. I mean, I think, to close, I'm not sure. I'm actually still not sure what Jim wants.
I want to repeal the Human Rights Act and get out of the European Convention and go back to what worked until Tony Blair, which was parliamentary sovereignty.
Yeah, but I think some of your critique of rights, you know, actually is a critique of law per se.
It's not.
It is. So, you know, judges, yes, have discretion, and judges are not fully reliable. Judges may promote their, you know,
was there law values before Tony Blair? Yes, there was.
So to that extent, you know, what you're advocating is, you know, it relates to the weaknesses of, you know, of legislation.
No.
You know, do we have the option realistically of doing away with legislation? No, or judicial interpretation of law. No, we don't.
Leave social policy making on the rights field to the elected parliament.
Yeah, but courts will still have to apply that legislation. So this is a little bit.
Fine.
This is a little bit about, you know, how society has become more complex. All of our expectations of what government can do, you know, have become more demanding and richer. And, you know, I think we're probably approaching the outer limits of that quite soon. What we can deliver, you know, what the organs of government can really deliver for us. I think there's a bit of a disconnect between our expectations as, you know, consumers of public services and what human societies are actually capable of delivering. So I think, you know, not all the blame that you want to attach to human rights should land at the door of human rights as such, and they, you know, remain as important data points for political discussions of the kinds that you want. You know, they are a means of structuring political debate and making it more transparent and accountable to us, and they don't have to defeat politics, I think, in the way that you're suggesting.
Okay. I'd like to say a big thank you to our panel, to Joanna, to David, to Jim, to Claire. Thanks to all of our questioners, and I hope you're going to join us.